Let's take a look at which employment laws apply to which situations. There are a few key contextual factors that determine which, if any, employment laws apply in a given situation. The legal environment differs substantially depending on whether public sector, government employees, or private sector employees are being considered. The terms public sector and private sector do not refer to whether a company trades its stock on the stock market, but rather to whether the employer is a government agency or a corporation. Beyond constitutional protections, which pertain only to public employees, there are often covered by state or municipal civil service laws, collective bargaining agreements, and tenure provisions. However, public employees are also subject to restrictions on their political activities, excluded from coverage under the NLRA and OSHA, and limited in their ability to sue for violations of federal law. In contrast to the vast majority of employees who lack employment contracts, unionized employees have many of the terms and conditions of their employment spelled out in enforceable labor agreements. Employers in unionized workplaces are also more limited in their ability to make unilateral changes in workplace practices without first negotiating these changes with unions. Discipline or discharge of a unionized employee is contractually limited to situations where the employer can establish just cause for the discipline or discharge. For purposes of some statutes, including the Fair Labor Standards Act and the National Labor Relations Act, size is measured in financial terms and coverage is limited to employers that exceed a minimum level of revenue. More often, statutes specify a minimum number of employees. For instance, both Title VII of the Civil Rights Act and the Americans with Disabilities Act limit coverage to companies that have 15 or more employees. These size limitations are not trivial. Almost 90% of firms in the United States had fewer than 20 employees in 2014, which means that the vast majority remain outside the reach of federal employment law. An employee's rights are affected by where he or she happens to live. Some states and cities go much further than others, and also further than the federal government in conferring rights to workers. The interrelationship between federal and state law is a complex legal matter. At the risk of oversimplification, states are usually free to enact laws pertaining to issues not addressed by federal law. State laws can, and often do, match or exceed the protections available under federal laws dealing with the same matters, but they cannot reduce the rights that employees have under federal law. Governments sometimes use the contracting process to leverage to get employers to implement desired workplace practices. For example, employers that contract to do business with the federal government and meet other certain criteria are required to engage in affirmative action as a condition of their contract. Most employment laws apply to any industry, but some are more narrowly targeted.